All right, let's get right into this explainer. We're usually drawn to legal stories that feature that classic David versus Goliath setup, right? The lone, determined individual fighting the system to get justice against some massive, powerful entity. But what happens when that whole narrative gets completely flipped on its head? Today, we're unpacking a really fascinating constitutional court case from South Africa. It's the 1998 judgment in Beinish versus Ernst & Young. And we're going to look at a pretty remarkable situation where an individual actually tried to weaponize the justice system itself. We'll explore exactly how the highest court handled someone who wasn't using the law to find justice, but literally using it to harass other people. It's a brilliant look into the really delicate balance between our fundamental rights and the actual integrity of the courts.
To really wrap our heads around the scale of this problem, just think about this number, 45. Between May 1992 and January 1998, just one single person, working alongside a closed corporation they controlled, launched 45 separate legal proceedings. I mean, think about the sheer volume of paperwork, the court time, the legal defense fees that 45 lawsuits require. And they weren't just going after one big corporate enemy either. The targets were all over the place. We're talking commercial firms, a bank, a trust, a firm of attorneys, a firm of accountants, 4 different individuals, and even a taxing master. Just an absolute barrage.
And if you break down those 45 cases, it becomes pretty clear that this was not some noble, uphill pursuit of the truth. Out of the finalized proceedings, 27 of them were completely unsuccessful, just total losses. Only one single application for leave to appeal was initially successful, and even then, the actual appeal was ultimately dismissed anyway. And the remaining 17 matters still pending. So as you can see, this wasn't a search for justice. It was a massive wave of litigation that completely clogged up the courts and basically forced the respondents into this seemingly endless, exhausting cycle of defending themselves. So that brings us to the first major phase of this whole situation, dealing with a sea of litigation.
Actually, the high court judge who initially heard this matter literally described the victims as being awash in a sea of litigation. Because of this, they officially slapped the applicant with the label of a vexatious litigant. Now, if you aren't familiar, a vexatious litigant is a person who persistently and without any reasonable ground institutes legal proceedings. The courts noted that individuals like this completely manipulate how the legal system is supposed to function. Instead of trying to resolve a genuine, real-world dispute, they abuse court processes to harass, drain the bank accounts, and embarrass their victims for totally extraneous purposes.
Which leads us directly to the primary legal tool used to fight back, the Vexatious Proceedings Act. So you might be wondering, how do you actually stop a vexatious litigant? Because you obviously can't just politely ask them to stop filing lawsuits. Well, South African courts rely on a law from back in 1956 called the Vexatious Proceedings Act. It was originally passed to give judges broader powers to stop this exact kind of systemic legal abuse. Under Section 21B of this act, if a court is fully satisfied that someone is persistently filing groundless lawsuits, they can drop the hammer. And the High Court used this exact provision to order that this individual could no longer institute legal proceedings against anyone in any court without getting a judge's permission first. It basically froze their ability to sue altogether. But of course, that wasn't the end of it. Next up, we have the constitutional clash. Because, as you might expect, the applicant didn't just accept this freeze. They appealed their case all the way up to the Constitutional Court of South Africa. And that set up a massive legal paradox. On one hand, we have the Vexatious Proceedings Act, which heavily restricts a person's ability to file a lawsuit. But on the exact opposite side, we have Section 34 of the South African Constitution. And that section guarantees that everyone has the right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court. So the applicant argued that the act was entirely unconstitutional. They claimed it created an absolute bar, a sweeping restriction that turned a fundamental human right into a mere privilege that the courts could just take away. Which leaves us with a really heavy constitutional question. Can the government legally ban you from accessing the courts? To figure that out, we need to look at the court's solution, the screening mechanism. To resolve this incredible tension, the Constitutional Court determined that the act actually doesn't create a total permanent lockout from the justice system. Instead, it serves as a necessary escape hatch or a screening mechanism. If a vexatious litigant actually has a real, legitimate reason to sue someone, they can still do it. They just have to navigate a 2-step process first, which is effectively asking a judge for permission. Step 1, they have to prove they have a prima facie ground for the proceedings, meaning the claim has basic, undeniable legal merit. Step 2, they must prove the lawsuit is not an abuse of the court's process. It's kind of like a bouncer checking your credentials before letting you into a club. If you have a legitimate ID and you aren't there to start a fight, you get in. The court pointed out that, hey, if you've already demonstrated a propensity to abuse the system, you really can't complain when the courts ask you to prove your good faith moving forward. And that brings us to this incredibly powerful quote from Judge Montgoro J. She wrote, "A restriction of access in the case of a vexatious litigant is in fact indispensable to protect and secure the right of access for those with meritorious disputes." This is such a profound shift in perspective. The Constitutional Court is basically saying that protecting the court system from abuse isn't just a good idea, it's constitutionally required. The public has a vested interest in making sure the courts aren't bogged down by endless, groundless paperwork. Because think about it, if the courts are entirely clogged up by one vexatious litigant, then genuine, bona fide litigants, people who have actually been wronged, are denied their right to swift justice. So, with all that considered, let's look at the final verdict. The Constitutional Court fully acknowledged that the Act definitely does limit the right of access to courts, but as we know, rights are rarely absolute. To justify this restriction, they applied what's known as the Section 36 limitation analysis. This framework allows rights to be limited as long as it's reasonable and justifiable in an open and democratic society. So the court weighed the nature of the right against the critical importance of the limitation's purpose, which of course was to stop persistent, ungrounded harassment. They looked at how the limitation relates to its purpose and found that it's actually a really flexible, proportional balance. For example, the court noted that the further a new proposed lawsuit is from the litigant's historical targets, the easier it's going to be for them to prove their good faith and get that permission to sue. Ultimately, the restriction was found to be perfectly tailored to prevent harm. Because the limitation on the applicant's rights was found to be completely reasonable and justifiable, the final verdict was crystal clear. The application was refused with costs. But we aren't just talking about normal costs here. The High Court had originally awarded costs on an attorney and client scale, and the Constitutional Court agreed. They decided it would be entirely unfair to the harassed respondents, who were just dragged through yet another unmeritorious constitutional challenge, to bear the heavy financial burden of defending themselves again. Which leaves us with this final, really provocative thought to ponder. To protect the right to justice, must we sometimes limit who can seek it? This explainer shows us that a functioning justice system relies not just on open doors, but on actively preventing those doors from being jammed open by bad faith actors. By restricting one individual's ability to harass, the courts effectively safeguarded the right to justice for everyone else. It's a truly fascinating look at how the law must protect itself in order to protect us. Thank you for joining me for this explainer, and keep exploring the complex balance of our legal rights.